Hi everyone, I am Ash Ferguson from ProWritingAid, and today I'm joined by literary lawyer Bob Pimm. Bob is here to walk you through a basic introduction to copyright law, so you can be sure that your writing is protected. Welcome, Bob. We are so very happy to have you here today with us. We are looking forward to learning a lot today.
Okay, great. Would you like me to begin the presentation by sharing my screen now?
Yes, you can go ahead. So I'll just, give you the floor while I sit and learn like everyone else.
Okay, great. Thanks.
Okay, go ahead.
Great. Well, welcome everybody. It's a real delight to have this opportunity to speak to you about copyright basics that every writer should know. I've been working as a literary lawyer for many decades, and I've been involved in the book publishing business for many, many decades. And this is one of my great passions. So I'm delighted to be speaking with you. And those of you who are writers, I want you to know that I have great respect for what it is that you're doing. I work with authors all the time, and it's just amazing what authors are able to do and how brave they are to share their ideas and works with others. I do want to just start off, though, by saying that copyright law, of course, is a vast subject. In law school, it's at least a 6-month program, and if you were to go to a law library and look at the main resource that's used, it's called NIMR on copyright. It's I think 11 volumes now, and it costs over $8,000 to buy it, and it's updated at least 3 times a year. So here we are, we're going to try to talk about something that's covered in 11 volumes in just a short period of time. But we will have questions at the end and an opportunity for you to contact me afterwards if you feel like your question wasn't answered. All right, so let's just start off by talking a little bit about context, because I wanted to...
just a second, Bob. I'm really sorry to cut you, but for persons, just as Bob mentioned just now, if you look at the bottom of your screen, you'll see a Q&A box. So if you have any questions in mind during Bob's presentation, feel free to drop a comment in the chat box or in the Q&A box, and we'll get to it at the end.
Yeah, the questions will be handled at the end, and Ash will be monitoring the chat box. So she, if people ask a similar question, she'll try to pull them together into a single question. So hopefully we can get to all of those. Okay, so looking at this first slide, I'm talking here about trying to put this whole topic into context, because there are a lot of different book publishing business models. And as a result, the way copyright is handled in those situations is quite different. And so frequently when authors are negotiating with a publisher, they sometimes ask for things or are upset by things that are necessary within that particular publishing business model. And it's not a good idea to try to bring rules of thumb, let's say, from general trade publishing into a situation with professional association publishing. Like if the American Bar Association's book publishing program is publishing a book, the structure of that and how copyright is handled is going to be different than if you were doing a book with Penguin Random House. Same thing, especially with things like self-publishing, where people use a lot of service companies to help them. And those self-publishing service companies have many, many different business models. And it's very important to look at within that how they're trying to handle copyright. So this first slide is just to try to emphasize all of the different ways that books are published and to consider that in discussing how you're going to handle your copyrights with these different publishers. So let's take a quick look at a very dense slide. Not all the slides are like this, so don't worry. But this talks about some of the fundamentals. And that was also shared with you in a blog post a little bit before this program. So copyright protection under current law attaches from the moment the work is created and fixed in tangible form. So some of you out there who might be handwriting notes, the motion of handwriting and putting those words and letters on a piece of paper, that's fixing something in tangible form. If you were sitting by a lake and playing your guitar and sort of creating a song out of your imagination, and it's floating across the lake, that's not fixed in tangible form. That's just you singing. If you were recording it, that would be the case. But that would not be the same as writing something down. So all of these different issues that we're going to talk about today are greatly litigated, and that's why they can fill up 11 volumes for NIMR on copyright. Like, what exactly is something fixed in tangible form? When was the moment it was created? Things like that. Another key factor is that copyright only protects original works of authorship. And that is something that will appear in a publishing agreement whereby in the warranties and indemnities clause, the publisher is going to want you to promise that what you're providing to them is original. And if it's not original, you have gotten permission for anything that isn't yours. Okay, so copyright protects works fixed in tangible form. They protect published or unpublished works. So it doesn't have to be published in order to be protected. And you can register an unpublished work at the Copyright Office. Another key factor is ownership of a physical copy of the work does not transfer ownership of the copyright. So that seems kind of obvious, but sometimes people think that if they have a copy of a book that they got at a bookstore, that they can take things out of that book without having to worry about it, and that's not the case. Similarly, if you have a book, you are able to sell that physical copy without infringing the copyright. So if you have a book and you want to give it to a library, you want to sell it to somebody on Amazon, that single book, the fact of you selling that physical copy would not infringe copyright. Also, as a general rule, a work that's no longer covered by copyright is deemed to be in the public domain, which we will talk about later on in more detail. But basically, that means it is available for anybody to use in any way, and you wouldn't need to get permission. Another fact about copyright that's important is that it is a personal property right, and it can be put into a will, and you can inherit these rights because copyrights live on after the author or authors have passed away. In addition to that, it could be given away during the lifetime of the author as well. Also important is that there's no sort of set international copyright where you could do a registration at some place and get automatic protection against all unauthorized uses in all countries. So each country's laws will apply, and also any treaty obligations and treaty agreements would apply. And there are, of course, many international treaties whereby countries have agreed to protect a copyright if it's registered in the treaty country. But what this means is that you can't just make assumptions about what will happen to your copyright in different countries just because you registered it in, let's say, the United States or the United Kingdom. So two key terms in this sort of fundamentals area is the concept of creation and the concept of publication. So creation means when it's fixed in tangible form for the first time, and publication means the distribution of copies to the public by sale or transfer, lease or lending. And a public performance or display does not itself constitute a publication. And believe it or not, there are huge sections of NIMR on copyright where people are fighting over when something was actually created and whether it was published or not published. So a lot of arguments arise over these what seem to be very simple, straightforward definitions. So something that's important to know too is that copyright doesn't cover a lot of things that people think that it might. So a really important fundamental concept is that copyright law is not the kind of law that you would use to protect an idea. The kind of law that you would use to protect an idea would be trade secret law. And in those situations, you're talking about things like non-disclosure agreements, confidentiality agreements, and paragraphs within contracts of a different kind that ask for confidentiality. So if you registered a copyright for something you'd written and what you thought you were doing was trying to protect the ideas underlying your expression, that would not work. It's the wrong kind of law to protect the idea. And as I mentioned before about singing beside the lake and your song is wafting across the water in the evening, that's not fixed in tangible form, so that wouldn't be covered by copyright. Also, there has to be some level of originality to get protection by copyright. Now, the courts have generally not required that it be a lot of originality, but there are lots of interesting cases in this area. One would be where somebody took somebody's phone book and reproduced the phone book, and they were sued for copyright infringement. And the court said that because it was just a list of names and phone numbers, that was not original enough to rise to copyright protection. And the folks who built the book tried to argue to the court that it was a massive amount of work to compile this phone book. And shouldn't that gain protection? The court said, not if it's unoriginal. Another area where people think that copyright should work is for things like titles, like book titles, or names, or short phrases, slogans, things like that. And where that is protected is a different kind of law, and that's trademark law. Although, as most or many of you may know, trademark law does not protect a single title, but it does protect, and you can apply for a trademark if you're producing a series. So for example, you've all seen those dummies guides to all of these different topics. They all have the same exterior packaging, the same design, and so they can get a trademark registration to protect it. But copyright wouldn't apply, except it could be for the design. So all of these other areas here are areas that are not protected. They might be protected by trade secret law. They could be appropriately protected maybe by trademark law or patent law, but not copyright. And the last item on the far right bottom is an area related to the idea of originality. So things like the dates in a calendar, or weight charts, or tape measures, things like that, just don't have enough originality to qualify. So there's a lot of different types of copyright ownership. The most straightforward one, of course, is when you create a work that's original and you fix it in tangible form, you're the owner of the copyright, and it begins right upon creation. But there are a lot of difficult situations that are either intentional or unintentional where a joint authorship is created. And this means that two or more people own the work that was created. Now, there's a lot of problems related to joint authorship that can be prevented by using certain tools, and we'll talk about those a little bit later. But essentially, the idea is that two or more folks decide that they want to create a work, and their contributions are intended to be brought together into the work. And that's, of course, something that we're going to talk about when it comes to working with other partners, something that can be difficult to sort out. We are also going to talk about works made for hire in more detail later, but the idea there is that the person who's creating it isn't the owner of the copyright. It's the party that commissioned the work. So an employee that's deemed to be working within the scope of their employment anything they create is owned by the company they work for or the organization they work for. And in that particular situation, there doesn't need to be any kind of written agreement about that. Just the fact that they're an employee and what they're doing is within the scope of their work, writing pamphlets, let's say, they're in marketing or public relations, things like that, they don't get to own that, especially if they're using the company's tools and resources as well. Now, there could be a situation where somebody's being commissioned to do something, and that does require a written agreement. But let's say you're writing a children's book and you want to work with an illustrator and you want to acquire ownership of the illustration. It might be, if the work qualifies, it might be a work made for hire. And the fact that you're commissioning it in order to take ownership of the work in return for, let's say, a fee or a credit or something like that, that's okay, but that does need a written agreement signed by both parties. Other types of ownership are compilations, where people keep their copyright, but they've licensed it to be put into a compilation or a collective work. In the case of collective works, you often see situations where just the first publication right is given. So here's a few things about copyright formalities. In the past, copyright formalities were very important to maintain a copyright, but under the current law, the Berne Convention that the United States is a party to, almost all of these formalities are gone. Nevertheless, it can be useful to use a copyright notice. And I give you an example here. So basically, the idea there is to use the name, year, the words copyright or the small circle C, the name of the copyright owner, and the year that copyright is being claimed. It's, as I say, it's not required anymore, but it kind of eliminates the claim by somebody that they didn't know it was under copyright if you have proper notices. So under current copyright law, the term of a copyright, how long it lasts, is for individuals is the life of the individual plus 70 years from creation. And as a reminder, creation means when it was fixed in tangible form the first time. Now, if you've got joint authorship, is it when the first author dies or the last author dies? So it's when the last of the group, if it's 2, 3, 4, 5, 6 authors, it's the latest author's death plus 70 years. Also, when companies register, or if you decide you want to register under a pseudonym instead of your real name, or if it's a work for hire, there's a different term, and that's 95 years from publication or 120 years from creation, whichever is shorter. So this is something to think about if you're thinking of doing a pseudonym. If you're 25 years old and you're going to use a pseudonym, well, I guess 95 years from publication, that's probably the same, but maybe not. Maybe if you live till 90 plus 70, your copyright is going to last much longer. So you do need to think strategically there on behalf of your heirs and others who will own the income stream from your copyright after you've passed. With regard to registration, you can register works online now, and I've given you the URL for that, which is copyright.gov/registration. You can still do that in a manual way by mail, but it's more expensive, and they're really trying to incentivize you to do it online. It's an optional thing. There's no requirement that you have to register, but if you wanted to file a lawsuit in US federal court or other places, you're going to have to register the work to get standing to bring a claim. And so one of the first things that would happen if you said to someone, hey, you've done copyright infringement, and they take that claim to their lawyer, the lawyer is going to look to see if you registered the work. Because until you register the work, you're not going to be able to bring suit in federal court. And copyright law is federal law. Now, the Copyright Office gives a lot of incentives to do a timely registration. So the idea is to make sure you register within 3 months of first publication, because you have available to you something called statutory damages and also attorney's fees. And that's on a discretionary basis, but at least you can ask for them if you registered on a timely basis. That's a big factor in affecting how someone responds if you bring a claim. So as a reminder, publication means distribution of copies to the public by sale or transfer, lease, or lending. Okay. Now, when we were talking about duration of copyright, we said under current law, it's lifetime plus 70 years, or 95 years from publication, or 120 years from creation. But it could be that the work that, let's say you want to use something from some other work that's under copyright. Well, we have to look at what Copyright Act was in force at the time the work was published and what the situation is, because there was a 1909 Act, there was 1976, 1989 when the Berne Convention went into play. So there's a lot of different possibilities, and you would need to know whether they whether the work is still under copyright. In some of those earlier situations, there were 2 terms of copyright split in half, and you had to, after the or before the first term ended, you have to apply to get the second term. And you had to use things like a notice on every copy, or else it automatically fell into the public domain. So things you'd have to investigate whether the duration of copyright is still in effect for something you would like to use in your book. Another very important part of copyright is that many people just think of it as one thing, but it actually includes many rights. You control whether someone, if you're the copyright owner, you control whether someone can make copies, whether they can use your work as the foundation of a derivative work, whether they can distribute it, perform it, display, all these different kinds of things. And so there's economic value to every single one of these rights that a copyright covers. And so you have to be cautious when you see an agreement from somebody who says they want to help you do your book, or something like that, and they have in there that they want the copyright. And yet they don't really know how to do certain distribution, right? If they say, I want the copyright for the entire world, and maybe they don't have the track record or the ability to distribute it for that. So we'll talk a little bit more about that in a minute. The other interesting thing is every one of those rights has economic value by being divided up into different ways. So you could divide the right to make copies by a particular time period, by particular territory or territories, or even by languages, right? So I'm going to give an example here of ways to divide it. So you've got all of these ways, and notice beside time and territory and languages, I say, is this exclusive, or are you doing this on a non-exclusive basis? So one example with the arrows is, okay, I'm going to grant a license for my copyright for X number of years. The territory is going to be North America, and the language is going to be English. And then you could be drawing lines differently, like for a certain number of years to Australia in English, or a certain number of years to Europe in English, French, German, etc., right? So lots of economic value for each one of those rights divided up into all these different ways. Another important thing to consider is the whole sort of development stage of exploiting your copyright. Like, what do you need to be thinking about related to your copyright as you go through the process of bringing it from an idea to a finished manuscript and afterwards. So we talked about that copyright does not protect ideas. So copyright's not the right thing, but maybe trade secret law would be appropriate. And if you have an idea that has tremendous economic value, that just the idea alone, whether you were the person who expressed it or not, is so valuable, then maybe you need to be using things like NDAs and confidentiality elements in your agreements. And a lot of people, when they're writing their books, they're working with other people and they're collaborating. They work with developmental editors, copy editors, proofreaders, illustrators, and frequently, if they're doing self-publishing, the self-publishing service companies that have a big team. Well, that is a situation where you do want to consider using agreements that will better protect your copyright. You don't want a situation where one of these people pops up later after you've got a really successful book and they say, well, I was really a joint author. And remember, without a writing to protect you from that, it's potentially there's evidence there that they're the one who helped write the key scene that was used in the book proposal to sell the book, or other aspects of their collaboration with you. So it's very important when you're working with other parties that you develop a plan to have a written agreement that makes sure that your rights and your copyright don't accidentally get diluted by claims of joint authorship or even accidentally transferred, as frequently happens with some self-publishing service companies. And then with regard to the agent, sometimes agents will add language in the so-called agency clause in the publishing agreement, which is an attempt to take an interest in the work itself, so that anytime you exploit that work, whether it be for the agreement that they helped negotiate or some other aspect of the work, that their commission is protected. And so this is an area where you have to be aware of, like, gee, what's happening to my copyright? Is the agent just going to get a commission for doing the work of making this sale, or are they attempting to use language either in the agency agreement or the agency clause or both to take a stronger interest in the work that maybe I wasn't aware of because the language was confusing, or I didn't fully understand it for some other reason. Same thing with publishers. We mentioned that that copyright is many rights, and some publishers are well positioned to exploit all those rights to tremendous benefit to you, but quite a few are not. And if you grant the rights in a blanket way to the publisher, you have possibly lost future income because they don't know what to do with it, and they don't know how to respond to others who ask them to do something with it, like a producer who comes to a university press to buy film and television rights, and they botch the deal. Okay, so one of the interesting things about publishing agreements is conceptually you can divide them almost in half, where a whole bunch of sections of the agreement talk about creative control, and another part of the agreement talks about money, and sometimes they're intertwined. But both sides have implications for copyright and how the publisher is taking control of the copyright and its effect on your creative control and its effect on the income that you might earn from it. And so we have to look really carefully at these sort of two concepts as you go through the agreement to make sure that your rights are not being infringed or taken advantage of. Same thing where they said, remember I mentioned before, in the warranties and indemnities, they're going to say you have to have, it's got to be original to you, and you control these rights that you're granting to us. And so that brings up the whole issue of permissions and whether you need to get permission for something? What is it in the public domain already? Do you have to pay for the permission, or is there a way to use the work in some way where you're not required to do it, but that you're able to show the publisher you have control of it in an appropriate way? And then, of course, licensees. Are you giving, if you are licensing the work, is it exclusive, non-exclusive? What are the territories, the language, and the term, and so on? And we're going to look a little bit at that in more detail later as well. So any part of a copyright can be transferred, devised, inherited, assigned. It can even be used as collateral. The income stream from a book can be used as collateral for a loan, like a mortgage. But any kind of transfer where you're actually giving your copyright to somebody else has to be done in writing, and it has to be signed by the copyright owner. And so frequently people who think they're buying it from you, maybe someone who's commissioning it, doesn't have a proper writing. And so there's a little bit of ambiguity there. And you may still have your ownership of your copyright, even though they think they're buying it from you. So to be professional, you have to recall and make sure that if you're actually going to transfer ownership, you need to do it in a writing, and it has to be signed. So with regard to licensing, that is the kind of thing that does need to be in a writing, and it does need to be signed. And it doesn't necessarily transfer all of the rights. It can be portions of it. But here's kind of a diagram that shows you some of the many issues that people worry about and think about as they look at a publishing agreement or any other form of licensing. Things like royalty rate, and what's the base for the royalty rate? And you might say, what is he talking about? Well, in a publishing agreement, are they going to give the royalty rate as a percentage off the cover price or the so-called retail price? Or are they going to give it off of a net proceeds base? And if so, off of a net proceeds base, what is that? How is that defined? Is it X percent, 10% of a minus number? Believe it or not, I've had are going to be involved in that. So let's talk about the topic of work made for hire in a little bit more detail here. So this is the idea where you could be the person who's being commissioned, or you could be commissioning somebody. So if you're commissioning somebody, or you're the person who's being hired on that basis, then it's an independent contractor relationship, not an employee relationship. So let's say you're ordering or commissioning somebody to do something. Well, under the Copyright Act, it has to be for the purpose of one of these types of works. And so you can see that it might be tricky to fit some of the works that you're doing into this, right? And so if you use the words work made for hire and the work that you're commissioning the person to work on doesn't fit within one of these, then that could be a problem. And so there are ways to add language to a work made for hire agreement that could scoop up the work, even if it was deemed by the courts not to qualify it officially as work made for hire. And so that would be, the way you do that is to write, instead of a work made for hire agreement, you use something called a collaboration agreement, which is more broad and allows for the work to still be controlled by the commissioning party, even if it's not deemed to be a work made for hire. And in that particular case, you always have to have a written agreement, and it should be signed by both parties. In an employee situation, if the work's produced within the scope of employment, then that's going to be deemed a work made for hire, and the employer is going to own it. And in that situation, there's no written agreement required. So here's a little bit more about public domain. This is a situation where the work is available for anybody to use. So if a work was published prior to the existence of copyright law, like the works of Shakespeare, then that's in the public domain. Maybe the copyright's already expired, and we talked earlier about having to make sure you do an analysis based on what the law was at the time it was created to see if it accidentally fell into the public domain by not doing the requirements at that time or not renewing it. Or maybe it was lost, or maybe they never did what was necessary at the time to acquire copyright. Or maybe the owner of the copyright purposely dedicated it to the public domain. Or maybe there's some limited version of copyright because they've gone to the the Creative Commons and decided to put it into a form of open source through one of those open source licenses that you can see at the Creative Commons. And just as a note, most works that were published in the US before 1923 are most likely in the public domain. So that's a rule of thumb that is, for the most part, going to be something that if you're able to identify that you're going to be able to use it. And then here's a little bit more information about joint authors, because this is a very important area where a lot of problems arise and people come to seek legal assistance to unravel the situation. Now, I'll just point out that it's not just regular old writers that run into this problem. It's even attorneys who are writing books with other attorneys when they don't have a proper writing. So the best thing to do in a situation where you're working with somebody else on your book is to have them under some type of agreement, collaboration agreement or otherwise, where you won't accidentally have a situation where it becomes a joint work. So the basic idea is two or more authors intending that their contributions be merged into a unitary whole. And in that situation, what that means is that each joint author owns the entire book, and their obligation to the other author is to do an accounting. So if you did it with a joint author and it's using these default rules, there's no agreement, they maybe can go off and license it to a publisher that you don't like, and all they have to do is give you your half of the money, or if there's three of you, your third. Okay, there's a new, an interesting thing that's available in copyright now, which is called the termination right. And this is quite complicated, it turns out, because there are various problems with the way the legislation was written that makes it not so easy to accurately identify the window that's available to you to ask for your copyright back. But you have a right to terminate during a 5-year period beginning at the end of 35 years from the date of execution of the grant. So anyway, it's something that you should know about, but it is something that requires quite a bit of research to make sure that your window doesn't pass before you ask for it back, if that's what you want, or you know, that you're working within that window, but it takes too long, different things like that. So the effect of a termination is that your rights revert back to you, and you can then do whatever you want with your copyright. So folks are always wondering what to do to protect your copyright. So of course, it attaches from the moment a work is created under current law and fixed in tangible form, but professional writers do take the step to register their work, and they do it on a timely basis to give them their full rights and remedies. So that is within 3 months of first publication. Professional writers do use copyright notices, even though they're not required to just flag it and let people know that you're claiming copyright. Professional writers also use written agreements, whether they be work made for hire agreements, collaboration agreements, or license agreements. And of course, there may be instances where you have to send out a cease and desist letter, or use alternative dispute resolution or litigation, and in some of these cases, that's dictated by what's in your agreement. Many authors prefer an alternative dispute resolution process. I like to use a 3-step one, which talks about good faith negotiation. And if that doesn't work, a mediation, and then if that doesn't work, an arbitration. But some prefer litigation. So what about infringement? Whether you've infringed somebody's work or they've infringed your work, what are the things that need to be looked at here? So in a nutshell, the plaintiff has to show that they own the copyright. Seems obvious, but sometimes that's not clear, particularly if they didn't register. And that the defendant actually copied the work, or in your case, they have to show that you copied it. And that can be done by either direct evidence or circumstantial evidence, such as, well, we know you had access, and it's very substantially similar, not just the expression, but the ideas. And if there wasn't any access, and it's difficult to show, look at the striking similarity. And then after that, the defendant now has the burden to prove that they independently created it, and it's just a fluke, but there you go. Or what they took from the work is actually not copyrightable. Remember, we had that big long list of things that are not copyrightable, subject matter. Or maybe it was authorized. Maybe you have a permission, or it fits into the fair use defense of copyright infringement. So the checklist is established even if copyright applies. Is it in the public domain? Who owns it? Do you have standing to bring a lawsuit, or did they register the work? Do they have the evidence, the proof of infringement? Things like access, substantial similarity, that kind of thing. And are they within the statute of limitations? For copyright, that's 3 years from when the infringement was discovered or should have been discovered with reasonable diligence. And then there's this whole issue of what I call the risk continuum, or your risk profile. Some people are trying to get risk to 0, which of course can't be done, but they fall on the low end. They don't want to take risks. So if they can't get permission for copyrightable subject matter to include in their work, they're not going to do it. Others have a high threshold for risk, and they take risks, and they put things in their book that they don't own and they don't control, yet they make promises to publishers that they do because they think things about the owner that make them think the probability of the owner taking action are low. And every one of these things is different, right? Every person is different about their risk profile, and every situation is different as to how much risk you're taking. A really obvious case would be if you're going to take something from the Walt Disney Company, that's very high risk. If you're going to take something from someone who did a self-published book and there's only 100 copies in the world, and they appear to be the kind of person who's not aggressive about protecting their copyright, then that's a pretty low risk. So one thing I want to emphasize about fair use is a lot of people talk about it as one of the rights of copyright. And although there's a lot of academic writing about that it is a right, and it is part of the Copyright Act, but really it's a defense to copyright infringement. And it's a multi-factor analysis that the courts do. And regrettably, across the country, the way they do it is different. And so it's a pretty high risk defense for you unless a lot of these factors are in your favor, and it's very clearly in your favor. But the idea of fair use is, look, if we clamp down so much on copyright and commercialize it so much, then academics won't be able to use it for research. Or somebody won't be able to even write a review in the newspaper because they'll get attacked. Or people won't be able to make fun of it by doing parodies and things like that. So, you know, it used to be in the early days of this multi-factor test that number 4 was the big thing, which is like, is somebody losing income because somebody copied it? Whereas in the more recent cases, it's more about the so-called transformation. Did somebody change the original enough to add new meaning? So the cases are all over the map, but basically fair use is not easy as to raise as a defense, but it can be raised and it needs to be analyzed carefully, and particularly within your region to see what the courts within your federal circuit have been deciding about it. All right, so that was a Jeff Bezos style rocket ship journey through the basics of copyright. And on the screen now, I have some information about additional resources. The Copyright Office has very helpfully produced a whole series of circulars and fact sheets that you can read for free. They're PDFs and also online that can address almost every one of the topics that we've talked about and much more. Also, I put the URL up there for how you can look at the registration pages to see how that works. The Copyright Clearance Center, more about fair use at Stanford. And then the Creative Commons, which we talked about a little bit about open source type licensing. And then I've got 3 books here, which are from Nolo, which are also available as ebooks, and they have a lot of forms, and they're very, very helpful overviews. They're for lay persons. They're not for lawyers, but you don't have to have a lawyer to help you with copyright or trademarks, patents, anything. If you can understand it, move forward, you can do it without a lawyer. And of course, I have the obvious disclaimer that the presentation is not legal advice and we're not establishing an attorney-client relationship. And the books listed here are just for your information. I'm not endorsing them as being accurate, and I'm not using them to give you legal advice. All right, so Ash, I don't know if we managed to get any questions, but I would be happy to address those.
Thank you, Bob. I'm going to jump in and do the Q&A with you. Ash is just having a little bit of technical issues with her mic, so I'm going to take over there. We have a lot of questions. We're not going to get to all of them. Just to preface this, we do have 45 and about 12 minutes remaining, so we'll just get through as many as we can. So we'll just jump right in. First, are NDAs enforceable between the US and UK or other countries?
Well, those are contracts, right? So they're not being governed by like the copyright law in one country or another. It's an agreement that people are making that they will not divulge this information according to the structure of the agreement. So I don't see any obvious reason, unless there's some element of the structure of the agreement that wouldn't be permitted under that particular legal framework. So for example, let's say somebody had, as part of their NDA, some elements of non-competition, sort of preventing somebody from being able to work in a particular area of expertise, that kind of thing. If you were to do that in California, California law is pretty strict about not enforcing non-competition elements, but they're very strong in protecting confidentiality of secrets and different things within these companies. So that's hopefully answers that question. If not, of course, you can resend, and I'm presuming that I'm going to see all these questions and have a chance maybe to answer each individual later.
Okay, next one. Is there a database to search what has been copyrighted or copywritten?
Well, remember that copyright, if what you're asking is, can I see whether a work was registered or not? The answer is the United States Copyright Office. Remember, because copyright adheres without having to register, right? As soon as you create it and fix it in tangible form. So only registrations would you be able to search. And in the United States, anything registered after 1978 is searchable online. But you have to be sort of good at your Boolean searching and you got to spell things exactly right, because it's a very unforgiving search process, unlike Google, where you can mistype things and it'll give you the results. However, the Copyright Office in the United States offers a service to do research earlier than that. And that information is available on the copyright.gov website. And generally what you have to do is kind of fill out a form of what it is you want, and they get back to you with a quote on how much it's going to cost. Okay?
Okay. Our next question. If you post your work to a blog post or other website, does that hinder later republishing of the work by a publisher because of copyright?
That's a good one, because it could, if the terms and conditions of the blog are that you're transferring ownership to the blog. Now, are you transferring exclusive ownership? Are you transferring just first publication rights? What are you transferring if you are transferring? The mere fact of it being up on the internet doesn't mean that it's available for anybody to use. So it really depends on what the terms and conditions of the blog or even the system you're using. Like some blog platforms, if you look at the terms and conditions, they take a level of ownership in the work that is surprising. It's often related to marketing and promotion and different things, but it's quite shocking. Similar problems arise when people post their photographs on things like Instagram or Facebook and don't realize that the terms and conditions take an interest in it. And then the flip side of that is if you sign a publishing agreement and you make a promise in the warranties and indemnities that this has never been published before, and this is brand new, original, blah, 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 that wouldn't be a truthful statement. And so you would have to amend the warranties and indemnities to carve out and identify all the places where the work was published before. And hopefully the publisher is happy with that. As it turns out, as you all probably know, some publishers are saying, I won't publish your book unless you have a platform. Well, what's my platform? It's my blog. So I'm going to take all my stuff on my blog and make it into a book, and you're going to have to change the wording of your contract because obviously it's been published, but you're telling me I needed to have a platform with 50,000 people ready to buy the book. Well, there they are. That's why they're there, because they've been reading what I wrote already. So anyway, there's several issues all rolled into that question, but it's a good question.
Okay, next we have, as a self-published author, should I file my copyrights in my name or my personal publishing LLC?
Okay, so if you have formed a corporate entity to be your business, the business doesn't necessarily have to own the intellectual property. And sometimes when people create LLCs and they start adding members later on to raise capital or whatever, they sometimes lose control of the ownership of their intellectual property because they've transferred it to the LLC. So if you're sure you're going to be able to keep control of your LLC and you think there'll be tax benefits to it, I guess transferring to the LLC is a good idea. If you haven't transferred it to the LLC and the LLC doesn't own it, then you can't register it in the name of the LLC just because you have one. You have to go through the process of actually transferring it in a writing, signed and so forth, in order for them to be able to do that.
Okay, our next question. There are agencies such as Safe Creative that claim the material registered with them is protected. Do they work the same as the Copyright Office? Is that registration valid in case of a copyright infringement?
No. And all of the alternatives that people talk about, like putting it in the mail and posting it back to you, et cetera, that doesn't work. The only thing that works is registering at the United States Copyright Office. That's what the federal courts want to see. Now, if you don't have it and you have a whole bunch of other things and you can try to build a case, I guess so, but you'll lose against somebody else who has a registration. So no, registering the United States Copyright Office is the way to do it. All those other services that they talk about, like, oh, I have my screenplay with Writers Guild West and so on, that's not registering your copyright.
Okay, our next question. For the transfer process, does it automatically go to an heir after death, or is a legal will needed?
Okay, yeah, so I'm seeing a little note about somebody saying the poor man's copyright based on post-up. That doesn't work. Please do not, that is not correct. Poor man's copyright does not work. Okay, so back to this question. So in every situation where you live, there are certain default rules if you die without a will or a trust. And so it's quite possible that it's going to transfer according to the rules within that jurisdiction and go to your heirs. But there can be a lot of issues with that. So for example, people who do go to the effort of creating a will and naming an executor frequently select somebody different as their literary executor. And the reason they do that is because these rights live on, and there's income streams and opportunities to exploit them, get opportunities to get the rights back, to have a reversion. And so having somebody who's an expert in that area can really help. So yes, a copyright can be inherited without there being a will, but it's probably better to have a will in place, and possibly even to, if you have a lot of intellectual property that's earning income, to have a literary executor.
Okay, our next question. How is copyright affected if you have a ghostwriter for your book?
Right. That's a perfect example of what we were talking about earlier about collaborations. So you should have a written agreement with the ghostwriter, and that written agreement should be an agreement whereby the ghostwriter does not own, the end result is they do not own the copyright. Now, there's a lot of ways to work with ghostwriters and to compensate ghostwriters. Everything from a flat fee basis to a share of the income of the work to credit issues, all different kinds of things. But fundamentally, it needs to be that the work that they're doing is commissioned by you, and you're paying them a fee to do it, and in return for getting their fee, whatever it is, credit, money, royalties, whatever it is, in return for that, they have no claim on the copyright. Now, if you work with a ghostwriter and you don't have a written agreement, then you have a difficulty proving that they're not a joint author, right? So let's say the book becomes a smash hit and it's made into a movie, and you're standing on the stage at the Academy Awards accepting the Academy Award with the production team. And the clip that they used is something that your ghostwriter wrote, from scratch. They're going to be pretty jealous, and they might come out of the woodwork and say, look, I'm a joint author. I wrote the book, not them. And they don't have any evidence otherwise. So I get half of the income.
All right, unfortunately, we are out of time, but thank you so much, Bob, for being here. Your presentation was very informative, and I'm sure everyone here learned a lot in the last hour. So thank you again. And thank you everybody who came to attend today. We will have the replay posted within 24 hours on our YouTube channel if you would like to watch it again.
Okay, thank you. It was a pleasure to speak to your community. It's a great product, and I think it's a wonderful community.
That's so great. Thank you, Bob. Thanks, everybody.
Okay. Bye-bye.
Bye.